Good afternoon, and thank you all for joining us today. My name is Angelyn Frazer-Giles, and I am the president of INELDA. And I'm so pleased today to also be joined by my colleague at the National End-of-Life Doula Alliance and our colleagues at Institute for Justice for Rights to Rights. So with that, I'm going to just give a couple of housekeeping items. One is you will notice that the Q&A and the chat are turned off currently. We will be having the Q&A will be turned on at 2 o'clock. When we start discussion, you'll be able to ask questions at that point. This also is being recorded so that we will send out this recording at the end of the session. And I think that is all of the housekeeping for now. So thank you all again for joining. And I'm going to turn it over to my colleague, Ashley.
Thank you so much. And good day, everyone. My name is Ashley Johnson, and I'm the president of National End-of-Life Doula Alliance. And I want to extend a warm welcome to each and every one of you that are joining us today. First things first, and we are in a time where we are experiencing global grief. So I thank you all for creating a space to attend today's webinar. The National End-of-Life Doula Alliance is a nonprofit professional membership organization that is committed to supporting individuals, families, and communities to experience a positive change in how people experience end-of-life by promoting the work of end-of-life doulas. Today, we are thrilled to be collaborating with our esteemed fellow NEDA members, as well as training organization, the NELDA, the International End-of-Life Doula Association. One of NEDA's purposes is to define the roles and responsibilities, and we do this by creating best practices and standards of excellence. And we do that also with ethical and practical guidelines, which is why today's conversation is so important. Without further ado, I am honored to introduce to you to our esteemed guests, Ben and Christian from the Institute of Justice, who have been in the forefront of defending the end-of-life doula practices. Without further ado, let's dive into this vital conversation. Ben and Christian, the floor is yours.
Well, thank you all very much for joining us, and thank you to Angela and Ashley for having us. As Ashley said, my name is Ben Field. My colleague Christian Lansinger and I are going to be presenting today. We're at the Institute for Justice, and we'll talk a little bit more about our organization and sort of our role in litigating cases having to do with end-of-life doulas. And then we'll share some details about the cases. But first, I'm going to kick it over to Christian just to give a little overview of what our agenda is going to be for the afternoon. And we've got a presentation to go along with this, which hopefully will not be too distracting, but you'll find helpful.
Thanks, Ben. Hi, everybody. My name is Christian Lansinger. I'm a litigation fellow here at the Institute for Justice, and I'm also representing Lauren Richwine along with Ben and another attorney here at IJ named Jeff Rose. What we're going to do is we're just going to introduce kind of a little bit about what IJ is, and then from there go right into what these funeral licensing laws are and how they implicate the end-of-life doula practice. We'll introduce our clients, the Full Circle from California and Lauren Richwine from Indiana, and we'll talk a little bit about what these state laws say and how they could impact what end-of-life doulas do across the 50 states. From there, we'll talk about the Constitution and how these laws themselves implicate constitutional rights, specifically the rights under the First Amendment, which is free speech, and the right under the 14th Amendment. From there, we'll talk about what's going on in those cases, what's happened in California, and what's currently going on in Indiana, and then we'll conclude with some general lessons. But I think we can start with introducing a little bit about IJ if we want to go to the next slide.
Sure, and not to be pedantic, but just to pause briefly on the little italicized bit that we're talking about our views on, general constitutional matters and general views on how they might interact with end-of-life doulas. But, as I'm sure you hear whenever you talk to a lawyer, not meant to be individualized legal advice. This isn't creating an attorney-client relationship. This is just sort of sharing our experience. So just so that we're upfront about that. So the Institute for Justice is as I said when we got started, we're a national public interest law firm, which means that what we do is we represent all of our clients pro bono, meaning we don't charge our clients anything. And we try to stand up for people's constitutional rights around the country. And one of the principal things that the Institute for Justice does is help people carve out a space so that they can pursue an honest living without unnecessary or irrational government regulation that gets in the way. And as part of that, we've been in we've locked horns many, many times with the funeral licensing regimes across the country. I know that people joining this call probably are coming from a lot of different perspectives in a lot of different places. Some people are practicing end-of-life doulas. Some people might just be interested in this space and alternative end-of-life options. Some people may be considering exploring it. But if you have ever done, some of you may be licensed funeral directors. But I think that anybody who's interacted with this space knows that the funeral licensing authorities are often some of the most protectionist in the country. In a lot of different states, it's sort of a fox guarding the hen house situation where licensed funeral directors and morticians are regulating themselves, and they behave more like they're trying to keep out competition and keep out new ways of doing things than they are necessarily interested in consumer protection. And so the Institute for Justice has sort of a long history of locking horns with the regulators in this industry. So one of my favorite cases that we've done predates my time here, but our colleague who Christian mentioned, Jeff Rose, did this case. It finished about a decade ago, but we represented an abbey outside of New Orleans in Louisiana, who one of the things that the abbey did was prepared very simple pine caskets, which were a low-cost alternative for people who wanted to bury their loved ones, but didn't want or couldn't afford, sort of the full-fledged deluxe $10,000 casket that, sometimes a funeral home might try to sell you. And so these monks prepared these very, very simple caskets. You can see they're essentially just a pine box to place a body in. And the funeral licensing authorities went after them with a vengeance. And Louisiana is one of these states where the industry regulates itself. So it really was just a board of funeral directors who wanted to have the commissions from selling these expensive caskets and didn't like the idea that, these nice monks were selling a low-cost alternative. And we litigated it all the way up to the Fifth Circuit Court of Appeals, which is the federal appellate court for a large chunk of the South. And the court agreed with us that it was just completely irrational to say that these monks, who all they do is make a pine box, needed to be running funeral homes or needed to be licensed as if they were funeral homes or funeral directors, and that this was really just raw protectionism at work, and that was unconstitutional. That was about a decade ago, but we had casketing cases before that, including a victory out of Tennessee and in other states. And the problems we've had have continued. And it's not even necessarily always with funeral licensing regimes. So for instance, we recently launched a case earlier this year, which had to do with a green cemetery or a natural burial cemetery. So we represented the Quackenbushes in Michigan, who own a large plot of land, and they wanted to use it as a natural cemetery so that people who wanted to have a sort of ecological, low impact form of burial could just be buried in this forest to naturally decompose and to, as you can see, it's just a beautiful place so that their remains could rest in this beautiful natural environment. And the town, essentially passed a new zoning law specifically targeting them to say that they couldn't do that, and would have the effect of making it illegal just to have any sort of cemetery in the town. And so we've, representing them, have filed a lawsuit to say, in the same way that it was irrational and didn't make any sense, and there weren't any legitimate public safety or consumer protection interests in stopping these monks from selling caskets, it's just as irrational and arbitrary to ban the Quackenbushes from having this completely benign use of their property as a green cemetery. And so we're litigating that case. And it's like this sort of gives you the sense of, over a long period of time, we've been in this space of seeing that, as people want to explore new options, alternatives to the conventional funeral that kind of grew up in the middle of the 20th century, that they've run into regulatory trouble. And that often the funeral licensing boards out there in the 50 states are among the most protectionist of any regulator. And so oftentimes, we have to step in, or we have stepped in, to defend people's constitutional rights against those kinds of intrusions. And so we're now going to move on to talk about the two specific cases that we've been litigating in the end-of-life doula space. But before I jump into, I just want to say, there are, thousands of people out there in the country who are working in the end-of-life space, who are doing end-of-life doula work. And for the most part, they're able to do that without trouble. And so we're going to talk about sort of the two worst case scenario cases that have happened in the country where, we've had to step in and file a federal lawsuit, one of which resulted in a victory and one of which has so far been victorious. But I think I just wanted to start with a preface that these are two out of many, many, many people in the country. And so I don't want to give the impression that if you're an end-of-life doula, you're going to end up having to go to federal court to assert your constitutional rights. Rather, this presentation is about, for the two people who have ended up in that worst case scenario, how it's gone for them, and just to give you all a sense of, if you end up in the crosshairs of a regulator, what are sort of the constitutional right backstops out there to protect you if that happens. And so the first case that we had in this space is an organization, a small nonprofit in California called Full Circle of Living and Dying. It is in Nevada County, northeast of Sacramento. So if you go up into the mountains as you're driving northeast of Sacramento, you'll run into sort of these old mining towns, some of which are very, very cute and restored. And that's where this organization worked. And so the two women that you see in the presentation, the one on the left is Akila Murphy, who was the founder of this organization, and sort of our lead plaintiff in the case. And the other is Donna Pizer, who is herself a former attorney, but got really interested in this space and became an end-of-life doula working with Full Circle. And so what Full Circle did was they were volunteer end-of-life doulas. And so they would generally just give education in the community about end-of-life options. So talking about, what an end-of-life doula is. They would give people education about home funerals and inform people that in California, as in all 50 states, everybody has a right to prepare their own loved ones for death in their own homes and to host a home funeral, as long as they do so within a reasonable amount of time. And then they would, second, help people actually plan end of life. So they might sit down with somebody who was in the end of life stages themselves to come up with a plan for themselves, or would sit down with their family, or ideally everybody, to come up with a plan and just to figure out, which funeral if are we going to have a funeral home, and who is that? Who should we call? Which relative is going to be in charge of the paperwork? To just come up with a plan on what was going to be. What would the memorial look like? when the person was dying, did they want to be cremated, or did they want to be buried? Did they want to explore green burial options, things like that? And then the third thing that Full Circle did was actually assist at a home funeral. And so, the families have the right in California to host a home funeral themselves. And, there's nothing fancy or technical about it. But not everybody, people don't necessarily have experience with, dressing a dead body, or, placing ice packs around it to preserve the body for a day or two. And so Full Circle's doulas would come in and, if the family wanted, would help with, sort of these basic tasks that aren't complicated, but that most people don't have experience with. And throughout the entire process, the family maintained control of their loved ones. They were just doing what they were allowed to do, but had the help of these doulas who were experienced in it, if they wanted it. And all of that was going swimmingly. It was, people, I mean, you talk to their clients, people absolutely loved them. And in fact, several of their clients joined in the lawsuit that we're going to be talking about, because they found the services so valuable and they wanted to make sure that they could use them in the future. So for instance, one of our clients, her husband passed away and she found having the home funeral so moving that she wanted her children to do the exact same thing for her. And so she joined this lawsuit to make sure she'd be able to do that. But despite this being a fabulous service that people really appreciated, and even though Full Circle had good relationships with funeral directors in the area, they found themselves on the receiving end of a letter from the California Cemetery and Funeral Bureau, saying, well, we think that y'all might be doing funeral directing work. And they thought, okay, surely we'll just explain to them what's going on. Nobody could think that we need to be funeral directors. They had an informal meeting with the Bureau, and the Bureau was just adamant. Yeah, what you're doing is sufficiently close to being a funeral director that we think you not only do all of your individual doulas need to be licensed as funeral directors, but you need to be a licensed funeral establishment. Full Circle, the nonprofit does, meaning that they would have to spend hundreds of thousands of dollars to build or acquire a full-fledged funeral home that they would never use. And at that point, it became clear that this order that they had received from the government was essentially shutting them down, because there was no way that this small, low-budget nonprofit could afford to comply with those ridiculous requirements. And so they were put in a situation where essentially they had a choice of, well, do we file a lawsuit and fight this, or do we shut down? And that's when my colleague Jeff Rose came into the picture. Eventually, I joined the team as well, and they went down the lawsuit path. And we'll talk a little bit later about how that ended up for them.
And I'll speak about Lauren Richwine. We launched her case more recently, just last August, I believe it was, and we actually heard about Lauren from Aquila. Lauren had reached out, I think, to Aquila and mentioned that they had come after her with a similar order that she needs to shut down her end-of-life doula business. What makes her business, which is called Death Done Differently, a bit unique is that what she does is speech. All she really does is talk to people. She tells them in a similar fashion to Aquila and Full Circle. She talks to people about what their end-of-life options are. She helps them develop an end-of-life plan. And really what she calls herself a community death care advocate. And the way that Lauren views herself is that she is able to act as a disinterested advocate. She's not trying to sell them the various goods and services that funeral homes provide. Instead, her goal is to make sure that people can go through the end-of-life process the way that fits their wishes and fits their needs. She even has a binder of all of the different funeral homes, their packages and their prices. And though she leaves it to the funeral homes to kind of describe those services in detail, her goal is to allow people to make the decisions that are right for themselves, whether it be a home funeral, a green burial, or a more conventional funeral, which for most of our clients ends up being the case. what Lauren is based out of Indiana. She's based in Fort Wayne, and she's had her business similar to Full Circle for years without issues. No complaints, representing people, or not representing people, but helping people through this process. And the same process really plays out with the government. They get an anonymous complaint is filed with the state board alleging that she's committing the practice of funeral services, which we'll get into in a little bit. But this really ends up being is usually these complaints come from someone in the industry who, for whatever one reason or another, does not like end-of-life doulas entering the space and being part of the broader death care community, even though Lauren and Akila and others like them are not trying to overtake funeral directors or make sure that funeral directors are not able to do what they do best, but really are trying to be part of the broader death care community as a partner or someone who's helping them. And making sure that what Lauren described as a gap in the continuum of care. She, like Akila, was a hospice volunteer, and she saw firsthand the struggles of people coming from hospice and going through that process, that there wasn't someone there to be that lending hand, to be that emotional support that is needed. Anyways, the government files a motion to cease and desist, to silence her from speaking, and it's just part of these bureaucratic gears kicking in, where the complaints filed, a process begins, an administrative process, a little bit more formal in Indiana than it was in California. Lauren sent in letters from a former client, a local funeral director, and others in the community that supported her and supported her business. Unfortunately, there wasn't really much to go to. As we'll describe in a little bit, Indiana law, the way they define the practice of funeral services, is so broad that even talking about death constitutes a practice of funeral services. And thus, like Akila, for Lauren to continue her business, she would have had to not only get a funeral director's license, but a funeral home license and build a full-fledged funeral home with an embalming room and the rest. That's not feasible for any end-of-life doula, especially when they're not working with a funeral home. It would have cost tens, if not hundreds of thousands of dollars. So she faced the same decision that Akila did and Full Circle did, which is to fight with a federal lawsuit or to shut down entirely. So that's a little bit about Lauren's case, and you can see there's a similar pattern here. But we'll go from here. If we can go to the next slide, we can start talking a little bit more broadly about what these laws are and how they end up implicating end-of-life doula practice.
And just before we jump into that, we just wanted to remind anybody who's shown up late that the question and answer function will be opened at 2 o'clock, towards the tail end of our prepared presentation, so that people can ask question and answer then after we've had a chance to give the full presentation.
So the problem with these laws is that they're written extraordinarily vague. What happens is that they describe what the practice of funeral services is, and they're really defining a scope of practice, whether it's for funeral directors, embalmers. Some states, they have separate licenses just for funeral directors, a separate license for embalmers. Other states, they just have one license for all of the people involved in death care. And every state does this except for Colorado. And currently, Colorado has proposed legislation to enact their own funeral director licensure. So this really implicates everyone across the 50 states. And the issue is that the way they define these laws is they use language that could implicate end-of-life doulas because they're written so broadly. As I mentioned, Indiana is one of the worst instances where they say that even counseling others about the disposition of human remains, that's the language from the Indiana statute, constitutes the practice of funeral services. And this has real impact for people. These licenses are not just expensive, but they really take a lot of time. They take sometimes years of education. And of course, the building the funeral home, as we discussed with Akila and with Lauren, isn't even feasible. But it takes time, it takes money, and it becomes an absolute burden for end-of-life doulas to even do their practice. But anyways, if we could actually skip to the next slide, what I want to do is just kind of go through some of these laws. As I mentioned, Indiana's law describes the practice of funeral services as counseling individuals concerning the methods and alternatives for the final disposition of human remains. This is an example of one of the more strict laws that would encompass all speech about death, essentially, if the boards really wanted to actually enforce them. And to caveat that, as Ben was saying before, this is kind of the worst case scenario. We know that there's thousands of end-of-life doulas across the country, and yet this doesn't seem to happen, is not happening constantly as of now. But we know that this is kind of a worst case scenario. When they do enforce it, these laws are written so broadly that they seem to encompass a lot of what end-of-life doulas do. The more common way it's written is similar to what we saw in California. They use words like prepare or arrange or coordinate a funeral, which, at first glance, you kind of have to squint and think, does that implicate end-of-life doula work? And often it does. To give one example is out of Montana. The way that Montana describes the practice of funeral services is the making of pre-need or at-need contractual arrangements. And it defines arrangements to include planning the details of funeral service, including time of service, type of service, and if requested, acquiring the services of clergy, obtaining the necessary information for filing death certificates, comparing or discussing prices, including merchandise prices and financial arrangements. You start to hear where the way they describe the practice of funeral services really encompasses what end-of-life doulas do. And that has, as we'll describe in a bit, constitutional implications. Just to name a couple more examples, South Carolina has we talked about the funeral directors in the funeral industry having a tendency to act in protectionist manners. South Carolina defines their practice of funeral services to be engaging in the practice of funeral directing or embalming as presently recognized by persons engaged in these functions, which is basically saying we're going to leave it up to the funeral directors to decide who can and cannot provide death care services and require them that they fall under our licensing regime if they want to do anything in the death care space. And then just one more example out of Maine. They define practice of funeral services to include helping to meet the emotions and disposition of the bereaved, which, again, it's just the broader picture is these laws are written very broadly, and they're quite vague at times too. Put that together, and they can really implicate end-of-life doula services. We can go back to slide 11 just for a second. The last thing I wanted to mention is just that 10 states right now require someone to hire a funeral director. So all that means is that even if an end-of-life doula is providing services, at some point they have to reach out to a funeral director and partner with them to make sure that they are involved in some minimal level of process. If you go to slide 13 just for a moment, this is just kind of an overview from the Funeral Consumers Alliance, which you could find online, but it's just to show that the way these regulations are written, funeral directors have to be involved in the process in at least 10 states, including Indiana, where Lauren told us about this, about how she has to make sure that any client that she comes by, that they're able to reach out to a funeral director at some point in the process. But just to keep the broader picture in mind is to look at your state law, be aware of what that language is, and try to and look at other resources as well. I'm sure that Ashley and Angelyn can point to some as well, but there's the National Home Funeral Alliance Guidebook. There's the book Final Rites, Reclaiming the American Way of Death, and some other great texts that kind of help to shape what these 50 states laws are and how you can try to consider how those laws might implicate your own end-of-life doula practice. With that, we can turn over to constitutional protections. And Ben, I don't know if you want to jump in real quick. Otherwise, I can go right into the First Amendment stuff.
Yeah, so just to give a sort of an overview. So as Christian was saying, the way that this typically works is that most of these regulatory agencies are complaint driven. And so, most people out there, nobody complains about them. The regulators aren't even that interested in them. But, both the Full Circle case and Lauren's case show that what can happen if somebody does make a complaint. And in both those cases where 99% sure that it was a licensed funeral director or a cemeterian who made those complaints. And so then you get put into the bureaucratic system. And basically what happens is you describe what you do to the bureaucrat, and the bureaucrat lines it up against the statute and says, are you close enough that I think you need to get this ruinously expensive license? And so sort of the first line of defense is that you would hope that most of those bureaucrats would be reasonable and that they're looking at the licensing regime. And yeah, there are those very, very broad terms that Christian was talking about. But obviously the point of it is to license people who are doing embalming or doing cremations, or holding thousands of dollars in trust for buying an expensive casket, 5 years down the line. Those kinds of things which might legitimately be regulated. And so you'd hope that a regulator would say, well, somebody who's just talking to other adults about planning for the end of life, that's not what this regulatory system is really about. But unfortunately, because the language is so broad, as happened in both the Full Circle case and in Lauren's case, it's possible that the bureaucrat can go the other way and say, well, even if this isn't really the problem that the legislature was thinking about when it passed this licensing law, it's written so broadly that we think you fall within it. And if the government decides that you fall within the licensing law, then sort of the backstop is the Constitution. Whether it's the United States Constitution or a state constitution, state statutes and regulations and laws, at the end of the day, they cannot be enforced in a way that violates a person's federal or state constitutional rights. And so the Constitution sort of acts as a trump card, where if you can say, look, no matter how you can unreasonably read your state law how you want, but if that violates the Constitution, then I can come in and say, you're not allowed to apply that law to me because it's unconstitutional to do it. And if you make that claim, you can go to a court and ask for an order saying the government shouldn't be able to regulate me in this way because it's unconstitutional. And so we're going to talk a little bit about the two main constitutional claims that have been at issue in these two cases that we've done. And we'll just briefly talk at the end about other kinds of claims that the Institute for Justice doesn't do, but that you might want, that an end-of-life doula might consider if she ends up in the crosshairs of a regulator.
And just to add on to that, just as a reminder, these lawsuits are not they're not actually challenging the entirety of a funeral director licensing scheme. We're not arguing that funeral licensing or funeral director licensing in and of itself is unconstitutional. All we're saying is that when those laws apply to someone like Lauren or someone like Full Circle, that these laws need to be applied in a way that is consistent with the Constitution, whether it's under the First Amendment free speech or, as Ben will discuss in a little bit, under the 14th Amendment. The way you can think of it is funeral directors have their own scope of practice. You can think of it as a circle. And end-of-life doulas, as I know the National End-of-Life Doula Alliance, for example, they kind of define the parameters of what end-of-life doulas are and what they do. Those circles overlap to an extent. But there's other things that end-of-life doulas do that you don't normally attribute to funeral directors. It's one thing to require someone to go to mortuary school to study embalming, to study human anatomy and chemistry, if they're going to be embalming remains, or if they're going to be doing cremation or things like that. It's one thing to license that. Those laws are actually designed, and those educational requirements are designed for those very things. But when someone's just talking about death or trying to make sure that they're aware of what their options are, especially in an instance where the clients in the funeral industry, a lot of times they're going through grief, they're going through their own problems, to have someone alongside them with a helping hand to guide them through the process, someone who knows about the process. That's where we get to that part of the circle of what end-of-life doulas do that not only shouldn't necessarily be captured by the funeral director laws, but are actually protected by the Constitution either way, so that even if the circle of the practice of funeral services tends to overlap and say that you need a funeral director license under the law, as Ben mentioned, the Constitution is a trump card. And so that's what these lawsuits really are about. So in Akila's case and in Lauren's case, we lodged First Amendment claims, and it's including the First Amendment's free speech clause, which just simply says that Congress shall make no law abridging of the freedom of speech. But what does that really mean? What that means is that the government can't pass laws that tell you what you can or cannot talk about unless it has a really good reason. The way the court has kind of described this most recently is in a case called Holder v. Humanitarian Law Project, as shown on the slide. And what it's saying is, if a law, again, it could be a general licensing law, but if any law, the way that that law applies to you depends on what you're saying, it depends on whether you're communicating a message, then that law is regulating speech and it's subject to the protections of the First Amendment. And those are the way that the constitutional law works. The First Amendment provides very serious protection. The government needs to show a very high burden, showing this law is absolutely necessary to apply to whether it's Lauren or to Full Circle. It needs to have a really compelling reason and be able to show that whatever that law is actually satisfying that reason itself. So what our goal is when we're when we're presenting these cases to judicial courts, is to try to tell the courts at the first step, this is about speech. This is about someone's ability to talk to another person, communicate a message, whether it's about end-of-life care or any other advice. The broader principle is that advice, even on uncomfortable subjects like death, is speech, and it's protected by the First Amendment. Most recently, about 5 to 6 years ago, in a case called NIFLA, the court held just that, which is that the First Amendment applies to everyone, and that includes people that are professionals. So when you think First Amendment, you hear the First Amendment thrown around. A lot of people talk about it in reference to political speech or controversial speech. But the message that IJ has been trying to get across for some time now is that the First Amendment applies to everybody, and that includes people who are providing really important speech. For end-of-life doulas, it's speech, yes, within a profession, but that doesn't exempt end-of-life doulas from the same First Amendment protections as someone who's saying something really controversial or political. Those same protections apply even if the government regulation or the government burden is a licensure requirement. And that's kind of what the NIFLA case got at. So we've used these principles and applied them in our recent federal litigation for both Lauren and for people like Lauren. We have cases in North Carolina representing paralegals, representing engineers, all kinds of people where what they're doing in their narrow practices is speaking one way or another. We can move to the next slide. And we can talk from there. We'll talk about how the First Amendment applies in a moment, but I want to let Ben have a chance to describe the 14th Amendment, which is kind of the other way that we approach these cases, these end-of-life doula cases in front of the court.
Yeah. So there's sort of this it can sometimes seem an arbitrary distinction, but there's a distinction within the law between speech and conduct. And so if you're just speaking to somebody or writing, doing things that are just purely communication, that is speech, and that is protected by the First Amendment. And it gets very, very, very strict constitutional protection. As Christian said, essentially if the government wants to stop you from speaking, it has to show that it has a really, really good reason to do that, and that there's no alternative that could accomplish that really, really good purpose. But once you move into conduct, the Constitution is a bit more forgiving to the government. And so in that, when you're now in the conduct space, and so in the Full Circle case, that would be, when they're just educating the community about end of life, or when they're sitting down with somebody to prepare an end of life plan, that's speech. That's protected by the First Amendment. But then when they're physically assisting at a home funeral, it can seem a little bit arbitrary that, like, if you're talking to somebody about performing a home funeral, that's protected by the First Amendment. But the moment you're like there with them and helping to put a sock on a loved one's body, that transforms into conduct. It might seem like a hazy line, but it's a very important constitutional line. And so if you're on that conduct side of it, then the protections are a little bit different. And that's where the 14th Amendment to the Constitution comes in. And so what the 14th Amendment is one of the post-Civil War amendments. Before the Civil War, the Constitution just didn't apply to state governments at all. And after the 14th Amendment, it does apply to state governments. And it includes a couple important protections, including, as here, everybody has a right to due process of law and to equal protection of the laws. And what that has meant in practice, as it's been developed over 150 years of constitutional law, is that if you're in a situation like Full Circles, where you are providing a, what would otherwise be a lawful service to people that isn't harming anybody, that the government cannot stop you from doing that for a completely arbitrary reason. And in the same way, it can't treat you differently from other people for a completely arbitrary reason. Now, this is different from the First Amendment because, as I said, it's a more forgiving test for the government. Rather than having to show that they have this overwhelmingly good reason and that this is literally the only way to do it, is to stop your speech. Instead, it really is a test for, is this just completely arbitrary? And so if you're asserting the 14th Amendment, you have to show that what the government is doing is just irrational, that it doesn't have any connection to any legitimate state interest. And it's a high bar to meet that. So I don't want to give the impression that these are easy claims to make, especially compared to the First Amendment claims, but they are claims that plaintiffs do win. And they are actually, then, as I was talking about with the St. Joseph Abbey case, they're claims that win in the funeral and end-of-life space, precisely because the licensing regimes are so onerous and so irrational. And so it is possible to do. And so there are a few basic principles that we deploy to argue that, doing things like making our clients Full Circle and Lauren build funeral homes that they'll never use is irrational. And so even though they're hard claims to make, as this first quotation says, they're not toothless. And Craig Miles is one of the other casketing cases we did where we were successful in persuading a court of appeals that it was irrational to make somebody get a funeral home license just to build a simple casket. And so a couple principles that we deploy. One is that, the government can't just make stuff up. They're actually, if you can come forward with evidence that what you're doing is completely safe and not harming anybody, the government can't just hypothesize or come up with fantastical explanations for why it needs to regulate you. That there actually has to be something there. It can't be fantasy. Another thing that matters is that, is there a circuitous path? And so if the government is asserting that, well, it's really important that an end-of-life doula be licensed because we just, people, or when they're dealing with death, it's a emotional time. And so we just want to make sure that there's some regulatory agency out there to look after them. If that sort of general consumer protection interest is what you're asserting, well, there are already general consumer protection and anti-fraud laws on the books. It's a very, very circuitous way to get to that goal by saying, oh, you have to spend $100,000 to build a funeral home that you'll never use in order to do that. And so the more circuitous the route, the more skeptical courts will be. And then the last point is that in many jurisdictions, the courts have held that it's not a legitimate interest for the government to try to protect one industry over another. And so it's not, so in this context, it's not legitimate to say, oh, we're imposing this regulation on end-of-life doulas because we want to protect the pocketbooks of licensed funeral directors. I wish I could tell you that were the case across the entire country. Unfortunately, in certain jurisdictions, the courts have held the other way and said, yeah, the government can just nakedly prefer one group of people over another and impose regulations in order to favor the group that they like more. So that, unfortunately, these claims would be harder in those jurisdictions. But fortunately, in most of the country, the courts have been more reasonable on that front. And just to quickly address a few other claims that you or your lawyer might think about if you end up in the same situation as Lauren or Full Circle. If your end-of-life doula practice is inflected with religious, if you're guided by faith or by religion, the religion clauses of the U.S. Constitution or your state constitution might come into play. I won't get into the details, but they're not maybe as strong as you might, those protections might not be as strong as you might think, but they're another way to get at it and to trigger First Amendment protection.
And just to add on to that, we talk about these constitutional protections, but one of the things you look at first is still those statutes. Does the statute apply to me? And some of those statutes do have exemptions written out related to religious, like they basically say these licensing laws aren't going to apply in certain instances of religious gatherings. They're narrowly written, and you want to see what your state and the way that they've constructed the statute, the way they've actually described what a religious ceremony is. But look at the statute too. Even is there that way, if the Constitution doesn't provide the level of protection that maybe we want, and what Ben and I would advocate for, perhaps the statute itself can provide an argument separately.
Yeah, and there might be other provisions within, your state might have particular statutory provisions that might provide some protection. And your state constitution might provide protections above and beyond what the federal constitution does. So those are places to look at as well. And then, obviously there's sort of general constitutional principles out there that would apply to any law. And so, for instance, if your state is applying its funeral laws in a way that seems designed to favor in-state providers over out-of-state providers, there are constitutional principles, the fancy name is the Dormant Commerce Clause, but that protect people against that kind of discriminatory treatment as well. So, it depends, but there are potentially lots of options out there. The Institute for Justice, we don't do, just religion claims are not sort of in our bailiwick, but there are similar public interest law firms that do religion cases. If your practice is, particularly tied to a faith tradition, those kinds of options are out there. So I just wanted to we've talked about the First Amendment and the 14th Amendment because those are the claims that we've brought for our clients. But I just wanted to flag that they're not the universe of potential defenses out there if you find yourself on the wrong side of a state licensing authority. So let's actually talk about, I feel like we've been saving the best for last, which is how have these legal claims actually played out in court in the two cases that we've done. And fortunately, I can spoil it and just say it's gone very well so far. So in the Full Circle case, the one in California, we've essentially achieved a total victory there. So after going through the full litigation process, collecting all the evidence, sitting the government officials down and asking them questions under oath to explain what the heck they were doing and why they thought that it was reasonable, the court ultimately vindicated most of our position. And so on the 14th Amendment claim, the court agreed with us that at least as to the idea that Full Circle needed to get a fully licensed funeral establishment, that was ridiculous, and so ridiculous that it was unconstitutional. And so as you can see, I included a short snippet from the court's decision in that case, where the judge just, she looked at the evidence and she said, it just doesn't make any sense to make them build a funeral home that is literally going to sit empty because they don't do embalming or cremating or anything that involves a funeral home. And then for the First Amendment claim, by the time we got to the end of the case, the government wasn't even really trying to defend that it had the kind of overwhelming interest that would be necessary to shut down our client's speech. And so, the court said it was unconstitutional to make Full Circle get a funeral establishment license, called a funeral home license in other states, and that the state wasn't even trying to justify shutting down their speech, so that all of their speech was protected by the First Amendment. You might notice that left open a little bit of wiggle room for what about, so the funeral license license is out, but what about funeral director licenses? And California was a little bit different than Indiana, in that California is actually not as onerous to get a funeral director license. You essentially you need an associate's degree in any subject, and you need to take a test, but beyond that, it's just paying some fees. So in practice, the most onerous thing about it is that, as Christian was talking about earlier, funeral director and funeral establishment licensure is usually interlocked. So you need to do the whole kit and caboodle. But the court said, well, maybe if we kick out the funeral, having to build a funeral home, maybe just getting the funeral director license wouldn't be so bad. I think in Indiana, that would be a different story, where like to become a funeral director in Indiana, you need to like get a specifically mortuary degree. You need to embalm like 30 bodies, even if you don't do that as part of your end of life practice. And so it's like that, it's a much more onerous standard there. But in California, it wasn't quite as crazy. So the court was like, maybe that's okay. But at this point, like we had won 90% of the case. So the state agreed, look, we're going to go back to the drawing board, and we're going to do, as we see it, we're going to come to the conclusion that we should have come to from the very start, which is that it's ridiculous to make these end-of-life doulas get the full suite of licensure. And so they agreed that as long as the end-of-life doulas are doing what end-of-life doulas do, which means that the family remains like in control and that they're just providing assistance at a home funeral, that isn't going to require funeral director licensure. And so the bottom line is that in California, if you are in California and you're doing the kind of practice that Full Circle does, that I was describing earlier, that there is now very, very strong authority for the principle that you should not be regulated. So, just to be upfront, these rulings and this settlement decision, this order that we have with the government technically only applies to Full Circle. But I think that if you're someone else in California who does something similar to Full Circle, and they start to come after you, you would have a very, very strong claim that you should be treated the exact same way. And more specifically, we would be very interested in vindicating that claim to make sure that the California Cemetery and Funeral Bureau is not trying to get around the victory that we won for our clients, Full Circle. So if that happens to you, we would love to hear from you.
And then to wrap up, we have Lauren's case. And as we mentioned, Lauren's case we had a limited claim. We didn't bring a 14th Amendment challenge here because everything she did was speech. So really all we had to do was convince the court that what's going on here is she's speaking and writing, and those fall under the First Amendment. And that really was the most difficult hurdle, because as we mentioned, if the court decides that the case is a First Amendment case, the government has to show a really, really good reason why that law should be allowed. And in the case of silencing end-of-life doulas entirely, that's rarely actually going to end up being the case. And we've been successful. The word preliminary injunction, all that means is the court basically said Lauren is likely to win if we were to go to a full, a full summary judgment, a full hearing. And so at least for the moment, she can reopen her business, talk to her clients again, put her website back up, deathdonedifferently.com, where you can see the stuff that she lists is speech. And the website that got her in trouble from the things that were written on there, you can see it's back up because a judge said that as of right now, it's likely that what is written on the website and what she does is constitutionally protected. So the court said, because all plaintiffs do is speak, plaintiffs being both Lauren and her business, Death Done Differently, ordinary First Amendment principles apply. And what are those ordinary First Amendment principles? When someone is communicating a message and the law applies to them based on what they're saying. So in this case, because what Lauren is saying is she's talking about end-of-life care, she's talking about death. Therefore, the law applies. When that's the case, under the First Amendment, the government needs to show a really, really good reason. And they need to show that that law is nearly the best way to fill that really, really good reason. And the court, after we had to take time, and we have to in these cases, and something that your organizations can help with is the court of public opinion, of which judges are a part of, to describe to them what death doulas are, because that's how we have to spend some of these cases, describing them what death doulas are, so they don't get spooked or scared away by the idea of someone just talking to somebody else about death. And the judge here agreed, saying if families choosing what services they want from a funeral home find value in a knowledgeable advisor without a financial stake in their purchases, that is the consumer's choice to make. And she specifically said that the fact other non-funeral directors are allowed to offer and advertise similar services. There were some exceptions in Indiana law, like I mentioned, some religious exemptions. Some of those same exemptions apply in Indiana. And what the judge said was, well, they can provide these services. Why can't Lauren? And finalized by saying funeral directors, there's no interest in giving funeral directors a monopoly over end-of-life discussions, really fighting that inclination of some courts to say that protectionism is some legitimate interest of the government. So for now, Lauren's business is able to be back open, and our case continues on to the Seventh Circuit, which is one of those larger federal courts covering Wisconsin, Illinois, and Indiana. So we'll wrap up. I know we're short on time, but just to wrap up, review your state funeral licensing laws is kind of the first step. See what these are lessons, of course. We don't want to give specific legal advice again, but the general lessons from what we take away from these cases is reviewing your laws and considering what those laws are before you go out and obviously we know that again, that your organizations provide some level of a scope of practice that define what it is that you should and should not be doing, but consider what is and is not the practice of funeral services. And perhaps there's a way that you can conform your practice to those statutes first before you consider anything constitutionally related or any of this. And also, you consider using that language in disclaimers. And if you go to deathdonedifferently.com, you'll see Lauren's that's on the bottom of every page. What's really important is to make sure that people know you're not a licensed funeral director. You don't want to mislead anybody because that's not protected. Fraud is not protected under the First Amendment. And disclaimers are really important on your documents, on your website, because people don't know what death doulas really are in some instances. And I'm sure you've come across clients that don't entirely know what it is that death doulas can and can't do. So really taking that time to describe to them what death doulas are can really help both with your relationship with local funeral directors and try to prevent one of those complaints, but also just to kind of have those disclaimers to make sure that people are aware of what they're getting into, just from a general perspective of being a good professional. Ben, if you want to keep going from there, I'll turn it over to you.
Sure. I think that, if I wouldn't want to dissuade anybody from trying to, if there is a super broad statute out there, I don't think that you should just give up on being an end-of-life doula, but I think that the point is more just to the extent you can use disclaimer language to disclaim some of the specific, things in the statute that you don't do, that can be helpful. Just bearing in mind that for the most part, a licensing regime isn't going to come after you unless somebody complains. So, obviously I think that the most important thing that means is that you should maintain good relationships with your clients, as you should for completely independent reasons. But also, there's no reason to gratuitously antagonize local funeral directors that might trigger a complaint. But again, I don't think that the end-of-life doula community should give up on offering their services just because funeral directors don't like it. But if on the margin you can play nice, there's no reason not to. As we were talking about, there's this difference between speech and conduct. And so if your practice really is more like Lauren's and is just talking to people, you're going to have more constitutional protection. Non-tech, in general, the government, just frankly, the government has a pretty good reason to want to regulate things like embalming. And so, and I don't think that end-of-life doulas consider that to be within their bailiwick, but just keeping it, that's sort of an extreme example. But the more your practice veers into more technical stuff, the more license the government is going to have to regulate it. And then I think the last thing and this is very important, is if you do get a letter like Full Circle got or like Lauren got, you should talk to an attorney at that point, because you might think oh, I can just, surely the law, it would be crazy to say that, like, all I do is talk to people about end of life and, help them make plans. It's crazy to say I need to get a funeral home, but unfortunately, the way the law works is if you start having conversations with an agency, you might end up saying or doing things that might preclude you from bringing constitutional claims down the line, or that might prejudice you even if you choose to fight it in state proceedings. And so you should just realize, like, it's sort of, like when you're watching Law and Order, they say, like, anything that can, anything you say can and will be used against you in a court of law. It kind of works the same way in a regulatory proceeding. So it's good to have legal advice before going into the lion's den. And then just sort of the last thing is, as I've said, we have been litigating these kinds of cases. We've represented Full Circle and Lauren. We really like these cases, and I think that this is important, and it's an important space, and we're excited to take more of them. So if you do run into trouble, we would love to hear from you. There's the plus. So as I said at the beginning, we offer all of our services pro bono, which means we never charge our clients. That has pluses and minuses. The plus is obviously if you become our client, then you're getting, not to toot our own horn, but I think pretty top flight legal advice and representation for free. But the downside of it is that we do have to be very careful. Like, we are in this to make good precedent. And so we're looking for very particular types of clients who who will be very sympathetic to judges, and who are in it for the long haul. And so I all that to say is that we're not promising any representation now, but if you do end up in trouble with your state licensing authority, we would love to hear from you. And even if we can't represent you, we might well have people that we can put you in touch with. Or for instance, as I said, if you want to bring religion claims, we might be able to put you in touch with people who do those kinds of claims. But Full Circle and Lauren are some of my favorite clients, and I would love to have more end-of-life doula clients if you do end up in trouble. And so please do reach out if that does happen to you.
Ben and Christian, thank you so much for this very impactful presentation. Had just about everything you could possibly think of that could potentially happen to someone. And these cases are both a little different in different jurisdictions, and so the statutes are different in those jurisdictions. So I think it gives folks kind of a broad view of what could potentially happen, and your suggestions at the end, very, very well taken and received. So I am going to start off with the first question, but I'm going to also let the audience know that you can put your question in the Q&A section of down at the bottom. You just look for Q&A, and if you have a question to ask, just put it in there, and either Ashley or I will make sure that that Ben and Christian can answer to the extent that they can. It's Q&A, so it won't be in the chat, and you can look for two word bubbles in the Q&A section. So I'm going to ask just a first question. Ben, you put it out there that if someone's having an issue, they can call you. You may have opened up like a stream of people reaching out to you. But I'm curious as to the case that came up with the Abbey, like how long were they doing these pine boxes before the regulatory agency came after them? It just seems like, they're just like, as you say, monks that were building these caskets, and all of a sudden they just decided, okay, let's come after them. And I also want to ask a question in terms of precedent setting cases. Were there any cases that you used prior to these two cases that you had that you were able to take some precedent from, or were these like immediate like precedent setting cases in terms of that? The Abbey case was probably one of them, but were there any other cases that you used?
Sure. So to take the first part first, as you surmised, they had been making caskets for a long time, and they were very valued service in the community. In fact, they initially didn't even want to bring a lawsuit. Like they thought, okay, this is ridiculous. Surely when people hear about our case, you know, things are gonna become reasonable. And so their first step was not to like try to file a big federal lawsuit. They tried to go to the state legislature. They had good relationships with their local representative, figuring like, look, when people hear about this, they're going to realize that this is ridiculous, and the government will fix it without having to file this big lawsuit. But again, Louisiana's reputation happened to be accurate in this case, and the funeral directors really were just so powerful that they were able to shut down any challenge to their authority. And they said they were just adamant, like, we control the funeral licensing board here. We have the power to stop anything from moving from the legislature. And so there really was no choice for the Abbotts but to file a lawsuit. And so it was, years of them trying to find another solution, but ultimately that was the only one that worked. And then in terms of precedents, I think that the Full Circle case it's the first case that is in the specifically, dealing with end-of-life doulas. And so obviously it was a very important precedent for Lauren's case in Indiana. But especially for the 14th Amendment claim, it really leaned very heavily on the St. Joseph Abbey case and the other casketing case, the Craig Miles case out of Tennessee, which sort of set, it's obviously building a casket is different from end-of-life doula services, but I think it's sufficiently close that courts can see, okay, just because something touches death doesn't mean that the government has free rein to act completely arbitrarily. And so St. Joseph Abbey and Craig Miles were very important cases for the Full Circle win. And then for the speech side of things, I mean, there's just decades of Supreme Court cases standing for all, Christian, briefly went through what those principles are, but they aren't just out of the blue. There are decades of cases saying, like, even though lawyers are a highly regulated profession, there are a dozen Supreme Court cases saying they have First Amendment protection. Doctors are a highly regulated profession, but there are cases saying that they have First Amendment protections when they're just talking to people. One of the most important cases has to do with just like people in Vermont or New Hampshire, like trying to solicit and distribute information about how doctors were prescribing medication, which doesn't sound even as speechy as like what end-of-life doulas are doing. And the court said, yeah, disseminating information is core First Amendment protected speech. So there's just a whole slew of cases that are very clear that if all you're doing is communicating to people, that should receive very, very strong constitutional protection.
Thank you, Ben. The next question from the chat, which is actually a few questions that are pertaining to resources. So Christian and Ben, by chance, can you list the legal resources that one could search their state regulations when it comes to the parameters of our conversation?
Yeah, there's not a central location that has every state's funeral laws like in one central spot. What I recommend is if you want the full detail of your individual state, just Google it and try to also find the state board often will have their regulations on the state board website somewhere. That's usually where the best place to find those regulations. But if you Google like your state, you can type in like board and then regulations. That's usually the best point to find where the complete list is. Some of the summaries that I mentioned before, there's the National Home Funeral Alliance Guidebook. There is a book called Final Rites, Reclaiming the American Way of Death. All of these provide a very brief overview of the 50 states, and a lot of them are kind of geared towards home funerals. They're not a complete description of all of the laws that would implicate end-of-life doulas. Most of them don't even have the definition of practice funeral services listed, but they at least give you an idea of kind of the requirements that if someone wants to provide a home funeral, what those are, which definitely has relevance into creating a practice of your own. But those are just a couple of sources. And perhaps Ashley or Angelyn, you might have some on your websites as well. But those are just some that I've come across. But again, I think the state board website is probably your first best bet to find the regulations.
Yeah, and most state boards will have, they'll be called a cemetery and funeral bureau or board, or they'll have funeral or cemetery and board or bureau in them if you're searching for them.
Great. So I'm going to take another question from the chat. I'm going to try to condense this a little bit, so apologies, but I want to try to get to the meat of your question. As I understand it, being compensated specifically for care of the body still treads into funeral directing. The California win was, as you said, about the right to educate the public about their right to care for their own dead. How can they do that? And how they can do that. But it does open us up to blur those funeral directing lines by getting paid to tend to the body ourselves because of the differences you cited between speech and conduct. This person's website services page said that they will clean, shroud, cool, and lay out the body for viewing, which even in California could be considered out of the death doula scope and could open them up to cease and desist or worse, correct?
So I think that question gets at sort of two different distinctions. So first, there's like the paid versus unpaid. And second is the speech versus conduct distinction. So I just want to address those separately. So first, paid versus unpaid. There is very, very clear. So when we're talking about speech in particular, there is very clear Supreme Court precedent that the fact that you're being paid for a service doesn't mean that you lose First Amendment protection. I mean, that just has to be true. Otherwise, a bookstore could be banned if they accept money for the books that they sell. And so the being paid or unpaid, like from a First Amendment perspective, our view, and I think there's a lot of case law to back it up, it doesn't matter. And in California, our victory there is agnostic as to whether there's payment. In Full Circle, they take payment in the form of donations, but they do accept payment for their services. And we, in Full Circle, have been clear from the beginning. We litigated the case the entire way, making it clear that there was nothing wrong with taking money, and that even though Full Circle was a nonprofit, they wanted people to be able to make a living out of being end-of-life doulas. So we 100% throughout the case did not think there was a distinction, and the court's ultimate orders do not distinguish between paid and unpaid. So I don't think that is a problem there. For speech versus conduct, as the question's getting at, some of the stuff that end-of-life doulas do, particularly once it comes to like actually assisting with a home funeral, if that's part of an end-of-life doula's practice, might be more on the conduct side. And so if you're dressing a body or laying out a body or placing ice packs around a body, that is conduct. It's not just communicating a message. And so that is, then you're in the 14th Amendment bucket rather than the First Amendment bucket. But if you're in California, I think you should, if what the questioner was describing sounds very, very similar to what Full Circle's services are. And so at least in California, if you do what Full Circle did and the family maintains control of the body, you're just there to help them. And that can include like helping them dress the body or place ice packs around it or dry ice. I think that you would have a very, very good argument if the government went after you. Like you just entered into an order with Full Circle saying that's okay. And so if that's what you do and you run into trouble, we would love to hear from you, because I think that the government should be treating you the same as they're now treating Full Circle.
Amazing.
But I guess one, so, that in other states where we don't have this good precedent in place, if your practice does involve physically assisting at a home funeral, as we've been saying, that's going to be that it's not, we were successful in those claims in California, but it's a harder claim to make than pure communication.
Amazing. Thank you. The next question from the chat, it says, could you please share more on the general lesson of non-technical activities in avoiding holding money pre-need means?
Sure, I can talk about that one. As Ben mentioned, some of the conduct, what those laws get to. When we talk about technical conduct, we're just talking about embalming, cremation, storing and burying remains, holding money in trust. We just mean, with the pre-need regulations, you want to be wary that some of those regulations may exist separately in the state code. So that's also another good thing to Google and try to find, because sometimes those regulations aren't housed in the same spot in the state law. But those are the kinds of activities that don't get that same protection that speech does. So on top of the fact that it might go kind of beyond what the typical end-of-life doula's work goes to, when we're talking about technical conduct, those are the kinds of things we get to. Almost every single state's practice of funeral services law in one way or the other describes those technical practices. Some of them do it as part of a funeral director license. Some carve out a separate license for embalmers and some of the extra technical, if you will, work that embalmers or they call it mortuary science. A couple of the states do. When it comes to that, those are the kinds of things that are likely least protected in the Constitution. Ben described that, we have that case now in California as an example to get past it, but with rational basis review, which is that low standard of review, it's an uphill battle. So just being wary of, treading as far away from anything that would be described as technical or medical from a common sense. Not only is it good from a legal standpoint, but also just the practical standpoint, which is that the boards are probably more concerned about people doing that without a license.
And just to just put a fine point on what pre-need, what we mean there is, that's like actually taking money and holding it in trust for services that you're going to provide in the future. That is going to be something that the funeral licensing authorities, I think, will look at and think, wow, this looks a lot like funeral directing. Whereas if you just sign a contract saying, in the future, I intend, I would like you to be present for my home funeral, and I'm going to pay you then. If you're not holding the money in trust, that's not what we would think of as pre-need. Like the thing that, and frankly, for good reason, that the government is concerned about, because funeral directors don't necessarily have the best track record in treating client funds properly, is if you're holding money, to be used later rather than just exchanging your services for money, that's going to be what creates the concern for licensing authorities.
So a couple of more questions, and we won't have time for all questions. I just want to make that disclaimer, but we will follow up and answer them, hopefully, a little while after if we can't answer them all here. So one question is about doulas who work with patients pursuing medical aid in dying. What if the loved one wants to use the option, but then wants to sue those who helped them? And I believe it's not the doula that actually does the prescribes the medicines. It's a doctor. But either one of you can answer that. And then someone asked, should they put the amendments in their particular jurisdictions on their website as a legal disclaimer?
So for the first question, obviously medical aid in dying, like that, as much as funeral laws vary across jurisdictions, medical aid in dying varies even more. But it is legal in California, and Full Circle provides information to their clients about medical aid in dying, and some of their clients have gone down that route. But as Angelyn said, that's a situation where I think an end-of-life doula should be very clear to follow the law, and it's ultimately a decision for the patient and the patient's doctor. And so I think that the First Amendment principles that we've been talking about support the ability of an end-of-life doula to inform his or her clients that this is an option that you could consider, to put in, if you want to put information on your website to the state resources about that. It's certainly these are legal options that people have a right to talk about, but you know, the actual prescribing medicine and things like that, you know, those are medical activities that, you know, I think the states can legitimately regulate. And obviously it varies state to state. And so, you know, if you're in a state that where it's illegal, you shouldn't give the impression that it is legal. But there's nothing, at least, you know, from our perspective, the First Amendment protects people's right to talk about these options. And I'm sorry, what was the second half of the question?
That was the part about whether they should put up the constitutional amendments themselves onto their website, I think, which I think it's probably not necessary because I don't think it's going to really protect you in any way. If you feel the need to inform people, that's great. What Lauren does, for example, is she has a resources tab that just lists the actual laws themselves, and that was something that was brought up in the early stages of this litigation, and the court said that, well, those are just the laws. But obviously, just be careful about trying to describe or explain the laws, because then you start treading on legal advice, and then that's the lawyer's scope of practice, which creates its own wormhole. So
I think one of the things that you offered was looking at the statute and then, you know, putting in your disclaimer section, like, I don't do X, I don't do Y, I don't do,
Right.
I don't do Z, as opposed to necessarily a statute being there, but just really looking at the statute and maybe having a lawyer help you look at a statute and just say, okay, I shouldn't do this, I don't do this, I don't do that, I don't do that, so that it's clear if they do try to come after you within the statute.
Exactly.
I think,
Yeah.
yes.
And I think that's worth emphasizing. It's like, you know, a disclaimer, you know, are not magic words that, you know, cast a spell that send the regulators away. What it is it serves two purposes. One, to just be very clear to your clients about the services that you're using so that a regulator can't say down the line, oh, you know, this person was deceiving their clients by making them think that they were a licensed funeral director. And then second, as Angelyn was saying, to the extent that your practice actually doesn't include the things that are in the statutory list, if you're just clear about that, you know, that might ward off regulatory interest if you're being very direct, that like, I don't do embalming, I don't do cremation, I don't do the things that you regulate.
And if I could just add, and it's kind of related to one of the other questions I see in the Q&A, which is saying like, should I avoid X word? Some of the laws, the way they're written, they actually have, in Indiana's one of these states, has laws that say using these words constitutes the practice of funeral services. And those laws are a bit more narrow because they're really described, like if you describe yourself, for example, as a funeral director and you're not, like we said, that might be considered fraudulent, and it could really get into the territory of where it's not protected. So consult those laws and look for that list of words to not use. But then otherwise you go back to that general principle of using words that maybe indicate speech more if that's what you do, or at least avoiding language that comes from the definition of practice of funeral services in your given state.
Awesome. The next question, are there some states or regions that are more hospitable to the latest wave in death care practices?
I mean, I think the short answer is yes, but unfortunately, you can't necessarily tell just by looking at the laws. So for instance, now I would say that like California is the gold standard because there's this great precedent out there, and the licensing authority has agreed, you know, to not to apply the funeral directing licenses to people who just do basic home funerals. But you wouldn't necessarily know that if you just looked at the face of the statute. So, you know, I think that the answer is states definitely vary, but I'm not sure that I can give a rule of thumb on who will be best or worst. I think that, you know, if you've been in the industry or you talk to people at groups like, you know, like NELDA, like NEDA, like the Home Funeral Alliance, like I think that you get an impression that some states have more rapacious licensing authorities than others. I know that like Indiana, most people typically put at the bottom of the list of like one of the worst. Louisiana is not great. And but it's not necessarily, and it's, you know, even within a region, it can vary quite a bit state to state. So I'm not sure there are differences, but unfortunately there's not I'm not sure that there's a way to give a clear answer on who's good and who's bad.
I would
Thank you.
I would just say the constitutional protections right now are still in a bit of flux across the various states. In addition to the fact that the laws, because they're so vague, I think the bigger concern ends up coming down to enforcement. And as Ben was saying, like, how is that state board individually enforcing these laws? And we talked to Indiana and Louisiana, but we unfortunately don't have the information to know exactly like how nice the state funeral boards are, how aggressive they are, and what the relationship is with end-of-life duels, which is where your organizations and everyone can really help, which is to let people know end-of-life duels are a very important part of death care. They're part of the broader death care community, and I think ultimately that's the bigger part is the enforcement issue, like even avoiding to get to the point where you have to launch a constitutional federal lawsuit. Is first convincing the court of public opinion, convincing those that people that death duels aren't something to be afraid of or concerned that they're sharing something super dangerous. They're really just helping people through these important but also uncomfortable decision making.
Okay, we probably have time for maybe 2 more questions. Someone is in Virginia and they heard that they're to help someone prepare an advance directive, one has to have a certification specifically to do that part of as a licensed to do that if they are not part of a licensed profession. So I don't know if you guys know anything specific about Virginia and helping someone prepare an advance directive.
So I don't know the specifics of Virginia's laws governing that. But I will say that at least in the abstract, you know, that sounds very similar to the core things that end-of-life doulas do. You know, it's talking to people about making their own choices for end of life. So, you know, if you're having trouble with a licensing authority over that kind of thing, you know, we'd be interested in hearing from you. But unfortunately, I don't know the details to be able to really talk about it.
Yeah, they wanted to know if it was a state law that could be then challenged in federal court, but I guess it would just depend.
Yeah, it's going to depend. Sometimes when you write documents like that, it comes down to kind of whether the words themselves have legal effect, whether they're considered speech or whether they're considered conduct. And that gets into that's you know, which path you go down, the speech path, the conduct path in front of the court is how protected it is. So that's it's a difficult issue. And unfortunately, we don't know the Virginia law specifically as a national law firm, but it is something we'd definitely be curious to hear more about.
Amazing. I actually want to be mindful of our time with Ben and Christian. Before we close out the webinar, Ben, Christian, are there any last things that you would like to share with everyone here?
I can start. I would just say that to start with really what Ben said a couple of times throughout the presentation, really just to bring it home, which is that we mean this to be as uplifting as possible, understanding that this is the worst case scenario, that these laws, they are vague, and sometimes it just kind of comes down to who's feeling upset in a given state and wants to write one of these complaints to shut somebody down. The hope is that these lawsuits are going to change that, and that they're going to make it so that end-of-life doulas don't have to just kind of sit there and in this gray area that exists right now and wonder, is their practice protected or not? We're not saying that like end-of-life doula work needs to stop because it's going to be. All we're saying is that if do what you can to, you know, get along, and if that complaint comes, then consult an attorney. But by and large, just understanding what your constitutional rights are, understanding what your state law is, allowing that to kind of fill into what disclaimers you use and how you describe your practice on a day-to-day will go a long way to hopefully avoid one of those complaints coming down the pipe. But it's not meant to be anything pessimistic in any way. It's merely to say that make you aware, should these things happen, what your options are and what you should consider.
Yeah, I second that 100%. And I think that, as Christian has been saying, that the more end of life doulas become, built into the mainstream, and the more people work with them and the more they know about them, it will just seem like, I think it will seem less unusual, and legislators and licensing authorities and judges will just see them as, well, this is part of the ecosystem of death care, and it doesn't make sense to lock them out because, in the 50s, conventional funerals were done this other way. And so, I hope, obviously, unfortunately, the end result of this talk is that it is a gray area, but it's a gray area where most people have not run into trouble, and where if you do run into trouble, there's some pretty strong constitutional principles behind you. And so I hope that people will continue to work in this space, and I hope it will be a virtuous circle where the more people who are in it, the more people become comfortable with end-of-life doulas, the more obvious it will become to judges and to lawmakers that end-of-life doulas aren't a threat, and that they should be treated as an important part of the death process.
Perfect ending. Thank you so much, Ben and Christian. Really, really appreciate it. Again, thank all of you for joining us. We really apologize if we weren't able to get to your question, but we will follow up with you. There was definitely interest here. So we will get back to you, and this recording will be sent out to those who registered. And on behalf of INELDA, I would like to say thank you. You can find us at inelda.org, and I'll turn it over to Ashley to close us out.
Awesome. Well, thank you. I would also like to thank everyone here for joining us today. And you can find us on the National End of Life Doula Alliance. It's nedalliance.org. And as we navigate these complexities when it comes to end of life and advocacy, I really am very thankful for Ben and Christian for their time and their expertise of representing end of life doulas. Thank you.